Okay, I think that that's everybody admitted. There was quite a lot of people who've joined, so we had to wait a little while for them all to be admitted, and there may be other people who join as we start. But I wanted to first welcome you to this Garden Court webinar about protest rights. My name is Stephanie Harrison. I'm a barrister working in the Civil Liberties team in Garden Court, and although I'm primarily involved in civil work, the topics that you're going to consider today really focus on protest rights in the context of criminal law. We have two speakers who are going to speak on two topics. The first, Tom Wainwright, is going to speak about protest, the pandemic and proportionality. He's also going to look at the limits that lockdown has imposed on fundamental rights. And secondly, Talia Maraj is going to give you an update on the case law, particularly from the European Court of Human Rights, to see what developments they have and how they might be deployed in your criminal practice when you're defending cases with a protest aspect. So that's the introduction to what we're going to talk about. There are some basic rules that are set out in the chat about the conduct of the seminar, which I'm sure you're familiar with if you've been involved in these presentations before. We have, although it is about free speech, muted everybody so that the speakers are in control of who can speak. Because there are so many people participating, if there are questions, the most effective way of doing that will be if you could put your question into the chat room, and then I will field those questions and put them to the speakers at the end of both their presentations. We are going to be recording this. I hope that nobody has any objection to that. That's so that it can be used for other purposes. If there are any technical problems, obviously if they're to do with your own system and technology, there's nothing much we can do about that. But if you think it's a problem with our Zoom system, then Amy is able to potentially deal with any problems that you do have, and you can contact her directly in a private space. So she might be able to help with anything like that. I think that that's probably everything. If there are any other vital things that I've missed about the technicalities, they're set out in the chat room, and I'm sure you've seen them before. I mean, obviously we've got a very pressing topical issues that we're going to discuss today. I hope that you'll feel able to contribute and that there will be some exchange of ideas and discussion from the presentation. I appreciate it's more limited through this mechanism, but hopefully we'll be able to facilitate your active participation and contributions through putting in the questions in the chat room. So with that introduction, I'm going to ask Tom to speak first. Many of you may know Tom as a criminal practitioner. He does have a specialism in protest law. He's been involved in some of the most high-profile protest cases recently, representing Caroline Lucas MP and other cases such as the Stansted 15 and Rotherham 12. His work has covered many of the main protests that have taken place in recent times, whether that's student protest, the Occupy movement, Extinction Rebellion, the Million Mask March, a lot of anti-fracking work, and anti-road building protests. And so he's a person with very extensive experience, and he's put that to good use as one of the authors of the Protest Handbook, which I don't know if you use that in your work, but it's one of the leading practical text guides for both lawyers and activists. And I know that as well as lawyers, there are a number of people who are actively involved in campaigning and protests who are participating in this webinar. We'd very much like to hear their contributions as well as anyone else's as to how these laws operate on the ground and contributions as to how they may be properly defended. There will be a new edition of the Protest Handbook in November. That's my plug for Tom's book, but I think it's worth plugging because it's an excellent practical guide to promoting and defending protest rights. Tom, over to you.
Thank you very much. So I know everyone's on mute, but if you can't hear me, then do wave frantically in case my microphone packs up. I'm going to start hopefully sharing the slides so everyone can see those. And this works. Let's start there. So liberties in lockdown, and I just wanted to start by talking about the aim of this talk and what it is and isn't intended to do. In terms of what it isn't intended to do, it's never our role as lawyers to tell people how they should and shouldn't protest, in my view. The importance and the beauty of protest is in part down to the instinctive nature of it, particularly when it's about important issues. And normally I find that demonstrators have good sense as to right and wrong, and where the law is in the way, why that's a problem and what's wrong with it and what needs to be changed. And our role as protest lawyers is, I think, to make the law accord with that good common sense. But without telling people what to do, it is important, there is an important role for us in advising people and promulgating the law in relation to protest, an important role in clarifying it where we can. And that's important to make sure that people are fully informed on what the legislation says and how the courts are likely to respond to a particular protest. And that role in terms of explaining and promulgating is particularly important when we're dealing with legislation like we're dealing with now. Legislation drafted in haste, badly drafted, constantly being amended, so that it's incredibly difficult for people to keep up with what the regulations say as opposed to the guidance, or what the regulations say in England as opposed to in Wales. There's a huge number of difficulties. The current coronavirus crisis has understandably prompted swathes of legislation. I think I've counted 162 pieces of secondary legislation, and a smaller number in terms of primary legislation. The only part of that that we're going to deal with today is the Health Protection Coronavirus Restrictions England Regulations 2020, which are at present up to date as of the 13th of June was the last amendment. No doubt there'll be further amendments next week and the week after. But these are the regulations which deal with gatherings. And so that's the first thing that we need to have a look at, because we're really focusing on protests in the perhaps more traditional sense of a rally, an assembly, a march, that sort of thing, where there's a large number of people. So we need to look at what the restrictions are on that in the first place. So the restrictions on gatherings are set out in Regulation 7. And essentially, we can leave aside gatherings indoors. We're talking about gatherings outdoors, and the coronavirus regulations say that you can't have a gathering of more than 6 people. The definition of gathering is set out: 2 or more people present together in the same place in order to engage in any form of social interaction with each other or to undertake any other activity with each other. It may be, depending on the facts of the protest, that it doesn't fulfill that criteria, but the vast majority of them will, I would have thought. There are exceptions to that, and I haven't listed them all or listed them verbatim, but in general terms, those exceptions include being present with members of the same household, attending a funeral, if you are a member of the deceased person's household or a close family member, and so on. There is similar exceptions for attending hospital, fulfilling legal obligations, education obligations, and the obligation, the exception for elite athletes to carry on training. And all of those are further defined in the regulations. There's also exceptions which apply where it is reasonably necessary to do something in particular. So reasonably necessary for work purposes being one of the ones I'm going to come back to, but also facilitating house moves, emergency assistance, and so on. So how do those regulations get enforced? Well, they can be enforced by a relevant person, which is either a police officer, PCSO, or a person designated by the Secretary of State. And if they consider that there's a breach of paragraph 7 of Regulation 7, they can issue a direction to the gathering to disperse, direct any person in particular to return to the place in which they are living, or remove them to the place where they are living, so long as they consider that it is a necessary and proportionate means of ensuring compliance with the regulation. So ensuring compliance with that initial regulation not to have a gathering of more than 6 people. Although there's reference there to necessity and proportionality, that is only in a very narrow sense. So it's not, is it necessary and proportionate generally? Is it necessary for this particular purpose as set out in the regulations? And there is the power to use reasonable force to return someone to where they're living. But that doesn't in itself create a criminal offence. The criminal offences, so far as we're concerned, are set out in Regulation 9. And so it's an offence without reasonable excuse to contravene a requirement in Regulation 7 or 8. A person who obstructs without reasonable excuse someone carrying out a function under the regulations, and an offence if you, without reasonable excuse, contravene a direction given under Regulation 8. So that's a police officer directing the gathering to disperse. And so what I'm going to focus on is the common denominator in all those 3 offences, which is without reasonable excuse. And what is a reasonable excuse? So that's not necessarily the only defence were you to find someone charged with an offence under these regulations. Because this is secondary legislation, then it's possible to challenge it in the course of criminal proceedings on public law or human rights grounds, and challenge a particular direction if that's what's in question, the direction by the particular officer on public law human rights grounds. And you may want to run those alongside reasonable excuse. But most of the time, the question of reasonable excuse is going to be where the focus of any defence lies. And so the question is, how does reasonable excuse fit with the right to protest if that's the reason for a gathering in excess of 6 people? And so what we need to look at is how do the courts approach the question of incorporating Article 10 and 11, the right to freedom of expression, the right to freedom of peaceful assembly, into a criminal trial. And they've approached it in different ways over the years, but the fairly recent case of James and the DPP sets out the current approach. It was specifically dealing with Section 14 of the Public Order Act, which is conditions being imposed on an assembly where someone breaches those conditions imposed by a senior officer. And they pose the question, what is the interaction between a particular criminal offence and the rights of the accused under Article 10? How do we make sure that those rights are protected? And essentially, it comes down to using Section 3 of the Human Rights Act and interpreting the legislation in a way which is compatible. And they looked at a variety of offences where Article 10 often comes up, and set out how the courts have in the past or how they should in the future deal with those offences in a way which gives full voice to the right to freedom of expression. And so, for example, the Public Order Act offences, and it's really talking about section 4, 4A and 5 of the Public Order Act, using threatening, abusive or insulting words or behaviour likely or intended to cause harassment, alarm or distress. And there's a defence within the Public Order Act for someone to show that their behaviour was reasonable. And so, as James spelt out, although I think as far as this offence is concerned, it was already fairly clear this is how you incorporate Article 10. The rights and qualifications under the relevant ECHR articles, and therefore the proportionality of any restriction on the right to protest forms part of the statutory defence. So when you're deciding what's reasonable, you have to bear in mind the importance of the right to protest, put simply. So that's perhaps the most useful guide when we come to dealing with the coronavirus regulations. They looked at how it's dealt with in other offences as well. So obstruction of the highway. Obstruction of the highway is an offence if the highway is obstructed without lawful authority or excuse. So that's lawful authority or lawful excuse. And they've again spelt out, and it's similar position in slightly different words, but in the latest case of Ziegler, that use of the highway is lawful. There's a lawful excuse if it's not unlawful in itself. So if you have permission to be on that particular highway and not committing any other offence, and the scope of the protest is reasonable. And they looked at things like, or said that the court would be able to look at things like the duration of the protest, what degree of obstruction it was, to what extent, effectively, did it interfere with the rights of others, which is one of the considerations in Article 10.2 and 11.2 as to when you can restrict the right to protest. But they also noted that there are other offences under the Criminal Justice and Public Order Act that in particular they were thinking of aggravated trespass under the Criminal Justice and Public Order Act. And in those cases, they've said once the specific ingredients of the offence have been proved, the conduct of the accused has gone beyond what could be regarded as reasonable conduct in the exercise of convention rights. What that was referring to was the case of Bauer, which dealt with aggravated trespass, and it's the mass incursion into, let's say, Harvey Nichols or Harrods, one of those, as part of a protest. And what they'd said in that case was that Article 10 and 11 don't come into play with aggravated trespass. Once someone is trespassing, then there's no basis for saying that they were exercising their Article 10 rights. Whether that's correct and whether that's something that needs to be looked at on the facts of a particular case is a separate issue. But the court in James have supported that approach and said there are some offences where it can't be justified on the basis of Article 10 or 11 considerations. So let's have a look at Article 10. I'm not going to look at Article 11 separately. But Article 10, as I'm sure most of you are aware, is the right to freedom of expression. Beyond argument that it covers the right to protest, and we'll have a look at the scope of it a little more in a moment, but it is subject to restrictions, in particular, for present purposes, public safety and the protection of health, which would be the government or the prosecution's argument, which would, they say, justify the coronavirus regulations. So Article 10 is a very important right. When Article 10 is engaged, Any restrictions have to be narrowly construed, and the justification for any criminal sanction convincingly established. One of the topics which Thalia is going to be talking about is the point at which criminal sanctions are justified when someone is exercising their Article 10 rights. Where does the boundary lie? And there's quite a bit of European case law on that really interesting issue. Where the expression in question relates to a debate on a matter of general concern and constitutes political expression, a high level of protection over the right to freedom of expression is required under Article 10. And so essentially that's saying there is a range of free speech, some of which is more important than others, not necessarily taking a particular viewpoint, which we'll see in a moment the courts are at pains to say they don't do, but drawing a distinction between political speech and, for example, advertising and commercial speech, which is at the other end of the spectrum in terms of the importance and the degree of protection that's required. Other important case law that we may want to look at in current context is the case of Tabernacle, which was dealing with a bylaw, objection to a bylaw which had been brought in, which prohibited camping near a nuclear weapons site. And the court held that that was an unjust interference with the Article 10 and 11 rights being exercised at the nearby peace camp, which had been taking place on a regular basis for, I think, over 20 years by the time this bylaw came in. And what they were looking at there, effectively, the Secretary of State's argument was that although camping was prohibited, the protest could be carried out in another way. And the courts said, well, that isn't an answer, because so far as this protest is concerned, the manner in which it takes place is indistinguishable from the protest itself. It is the camp. And so if you would say that this could take place in another way, it wouldn't be the same protest. And so despite the fact it could have been done differently, the court still held that there was an unjustified breach of Articles 10 and 11. And it's important to bear in mind, because one of the issues the court will consider when looking at proportionality of a protest is what alternatives were available, and would those amount to an effective right to protest. So putting it into current context, you may be justified in arguing if the prosecution would say, well, look, you can have a protest, it's just limited to 6 people. In my view, the six people isn't a protest, that's a picnic. That's not going to get anyone's attention, and that's not going to fulfill the criteria. It's not going to fulfill the role that protest is there for. And so there is arguably that it does impose a limit on the right to freedom of expression and assembly, limiting it to a particular number of people. The question, as I say, that we'll come on to is whether or not that restriction is proportionate. And then I've touched on this, the other things the court will bear in mind when we're dealing with it in a criminal context is the point at which criminal sanctions are proportionate. And there's a couple of cases there which Charlie's going to talk about in more detail in her talk as to where the boundaries lie. So, having looked at Article 10, we need to have a look at how that's going to be incorporated into the question of reasonable excuse in the coronavirus regulations. And I think it needs to be looked at in a particular context, because where we are at the moment, if you look at the rest of the regulations, is that we're not in full lockdown. There are now a large number of exceptions to the regulation against gatherings of more than 6 people. And those aren't necessarily all very well defined or delineated. But I think there's two that bear thinking about it in particular. The exception to gathering in more than 6 people where it's reasonably necessary for work purposes, and the exception for people gathering together where they are or are training elite athletes. And I think the question that we have to ask when we're trying to figure out whether exercising the right to protest will constitute a reasonable excuse is if these two, as a matter of legislation, constitute an exception to the general rule, then why and are these more important than the right to protest? Why would the right to protest be less important than going to work? Why is it, if we are free to exercise our economic rights, whether that be working and producing for the economy, or now that we can go shopping, acting as consumers, if we're free to exercise our economic rights, what is the justification, the convincing justification for refusing us our social, political, and human rights? And I think that's a real difficulty that any prosecutor is going to struggle with if they bring proceedings for people exercising the right to protest. And the other factor, and I've set it out there in terms of these prosecutions, is Dominic Cummings. It may not be a strictly legal issue, but in terms of the politics of all of this, where politicians have said that he had a reasonable excuse for travelling across the country and visiting a beauty spot, and so far as they were concerned, that's a reasonable excuse. Again, we have to ask, well, how is it? How could it be that that's a reasonable excuse and exercising the right to protest isn't? Now, whatever the politicians say, it's not necessarily the case legally that he did have a reasonable excuse. And there's a number of private prosecutions and judicial reviews and so on, which may get to the bottom of that question. And we have the review that was carried out by the Durham police. And they say that, well, there may be a breach of the regulations, but they weren't going to take any action. They didn't fulfill the criteria for prosecution. And it may be worth looking at in those circumstances, why is it that he doesn't get prosecuted and demonstrators exercising their civil rights do get prosecuted? It would probably be difficult to argue an abusive process on those grounds, but I think it would certainly be worth looking at, and certainly any prosecutorial decision could be put under pressure when it's looked at in that context. So if in principle exercising your right to protest could constitute a reasonable excuse, what are the factors that the court would look into and take into account in deciding whether it actually did amount to a reasonable excuse? And we can have a look at, as I mentioned, some of the exceptions, some of the factors which are set out in the case law dealing with obstruction of the highway in deciding whether or not a particular protest is reasonable. We would look at the duration of the protest, the location where it took place. A protest in the middle of the countryside where everyone can spread out more, for example, is very different to a protest in a more enclosed area. The degree of risk, because that's really where the Article 10.2 and 11.2 exceptions come in, the effect on public health, may take into account things like the extent to which social distancing was being recognised and followed so far as possible in the course of the protests, the degree to which face masks were being used. And the other factor which the courts will take into account is likely to be the penalty and the European case law when it's deciding whether or not a criminal prosecution was a disproportionate sanction for someone exercising their Article 10 rights, will bear in mind the penalty which was imposed, and it has to be acknowledged that in these circumstances, these regulations, the penalty is a financial penalty at most. A really interesting question to ask is whether or not the subject matter of the protest can be a consideration in deciding whether someone has a reasonable excuse. Now, as I say, the courts have been at pains to say that they don't get involved in that. And so in the Ziegler case last year, the courts are strictly neutral arbiters of people's rights. They cannot adjudicate on the validity or legitimacy of particular points of view. They cannot engage in discrimination as between different viewpoints. Not the function of the court to express a view about the acceptability of a political opinion, still less to express approval or disapproval of those opinions. So that's the official stance. First of all, one argument which I think would be worth raising is that that's all well and good, but where the protest is, for example, taking place because of a concern that people are dying unnecessarily, that action is not being taken to prevent that. The state perhaps is not fulfilling its duties under Article 2, and that people are being discriminated against to an extent that may constitute degrading treatment, may amount to a breach of Article 8, right to private and family life. Then a question which could be posed is whether or not that should add more weight, much more weight, to the importance of the right to protest when that is the subject matter. And so that's a matter to be considered. At the other end of the spectrum, one may pose the question, does that mean that we, the BNP, the football lads, whoever it is that marched through London this weekend, can also claim that they're exercising a political opinion? Well, first of all, the question is whether they actually that was their purpose. But even if it were, then Article 17 shouldn't be overlooked. It's an important article which has been incorporated by the Human Rights Act. And it's important to bear in mind when you look at Article 10 that you can't rely on the rights established under the Convention where your purpose is to destroy the very foundation of the Convention. And so it was brought into use in the case of Norwood in the UK, which was a member of the BNP displaying a poster which amounted to a public expression of attack on Muslims in the United Kingdom. And he was not entitled to the protections of Article 10 because the court found his actions were incompatible with the Convention values of tolerance, social peace, and non-discrimination. And so a march which fulfilled those criteria, in my view, would similarly not be entitled to the protections of Article 10 and wouldn't have a justification for breaching the lockdown coronavirus regulations. Couple more matters finally. Firstly, this, many of you will have seen these headlines in the papers on Sunday. I think it was police officers, the head of the police officers union, I think it was, calling for a complete ban on protests. There was quite a lot of legal misunderstanding in the reports of this as to exactly what was being asked for. And it's not entirely clear from the officer's statements what it was that he was saying should be done. He said, or is quoted as saying, "I urge the Home Secretary to be unequivocal in her terms that whilst we're under the threat of this virus, any large gathering or protest must be banned." The first answer to that is they are banned, as we've just seen. It's there in the coronavirus regulations in principle. There are the exceptions that we've discussed. But but effectively what they seem to want to say is that they want secondary legislation to say that exercising your right to protest cannot amount to a reasonable excuse. And were that to happen, that would be a real problem given our obligations and protections under the Human Rights Act. So that's, I would hope, likely to happen. As far as other restrictions on protest are concerned, it's just worth reviewing the sections of the Public Order Act. Section 12 can only be for imposing conditions on processions. Skip section 14, conditions on assemblies. Neither of those can be used to impose conditions which effectively amount to a ban. Section 13 can be used to prohibit processions only, not static assemblies, but that can only be done if conditions wouldn't prevent serious public disorder, not on public health grounds. And section 14A is for trespassory assemblies, and so that doesn't apply where someone is in a public space. There doesn't appear to be the power for the Home Secretary or the police or the Mayor of London or whoever else they were calling upon to ban protests in these circumstances, other than that which is set out in the regulations. And then finally, just quickly, just an interesting question which occurred to me about face masks. They're now compulsory on public transport, again without reasonable excuse. If an officer asks you to remove your face mask, it can, that will amount to a reasonable excuse. But what if you don't want to, out of public health concerns, remove your face mask? There's going to be a potential tension there with section 60AA of the Criminal Justice and Public Order Act, which is often used in a protest context. A section 60 order was put in place the other day covering a large area of central London. And that gives the officers power to direct someone to remove a face mask where they reasonably believe they're wearing it wholly or mainly for the purposes of concealing their identity. And the offence as drafted doesn't include any sort of a reasonable excuse provision. The case of Roberts I've mentioned makes it clear the officer's reasoning has to be lawful, it has to be necessary and proportionate, but I don't think that necessarily covers all conditions or the circumstances that we're thinking about where people are rightly concerned about removing their face masks in public. So there's potentially some tension so far as that's concerned. So a quick plug for the second edition of the Protest Handbook coming out in November. It is currently listed for pre-order, but I'd suggest waiting a little while. There's some kind sponsorship from, amongst others, Garden Court, which should reduce the price, and there are offers available for demonstrators to reduce the price further. But details about that will be coming out in due course. So I think that's everything from me, and I'll hand back to Steph. Thank you very much.
Thanks very much, Tom. I haven't had any questions that I've seen yet in the group chat. There still will be an opportunity, if anything occurs to you, to raise any questions on Tom's talk at the in the chat, and we can discuss them at the end. But we are going to move on to Thalia now. Thalia, again, is a practitioner who specialises in criminal law and civil liberties. She has a wide-ranging criminal practice, and her civil liberties work does also include inquests and public inquiries. She's currently working on the Grenfell inquiry and represented the Hillsborough families also. So she has a wide-ranging practice. Her specialisation in protest work has in particular focused on environmental protests and Extinction Rebellion activists who've been subject in recent times to increasing use of the criminal law. She is going to, as I've indicated, give you an update on some of the ECHR case law, focusing on a few of the topics that Tom has identified about the legal boundaries between what kinds of conduct and speech is protected. And obviously that's a major issue when you do have far-right fascist racist activists on the streets. What is it about, where does the law lie, and where are the lines drawn in terms of protecting their ability to conduct their form of protest? Not a straightforward topic, but one upon which I'm sure we want to have some views expressed. She'll also look at what is also an important area of line drawing in the context of direct action protests, which have also been the subject of quite concerted attempts, not just in the criminal context, but as you'll see in later seminars that we're going to cover in civil cases, with companies trying to constrain direct action protests and to condemn that as unlawful. Thalia will explain why that approach isn't right. And she'll also have a look at criminal sanctions that can properly be imposed if you are contrary to all the excellent ideas that are being advanced about how you might prevent a conviction in the event that there is a conviction, the sorts of penalties that can properly be imposed on protesters. So Thalia, over to you.
Thank you, Steph. Just bringing up my my screen. So I am going to be looking at 5 cases in particular, starting off with the case of Roberts, which is an English case which was decided last year, and it looks at the issue of direct action. And I'm going to move on from Roberts to look at the case of Baladasi, which was decided by the ECHR as recent as Friday. And then looking at the case of Alekina and Russia, then PWR and the DPP, and then finally Kasparov and Russia. Now, starting off with the case of Roberts and others, some of you may recall that this case was the case that looked at the convictions of protesters who had been engaged in protest against the fracking to be carried out by Quadrilla company. And the question that arose in that case was whether or not the imposition of immediate custodial sentence for a non-violent crime committed as a part of a peaceful protest was in breach of Article 10. Sorry. I'm having a little problem with my, sorry. And there is no doubt that direction, action, protest falls within the scope of Article 10 and 11. Now, this issue has been considered by the ECHR in a number of cases, and the question under consideration was the proportionality of a sentence imposed for crimes committed in the course of peaceful protests. And the European Court, in examining this issue, looked at a number of cases where the terms of the protest activities ranged from various activities, including a grouse shooting and breaking into a construction site to impede engineering works. This was looked at in the case of Steele and the United Kingdom. In the case of Barraco and France, which was considered, a suspended sentence was imposed, as well as a fine, and it was considered proportionate in a case where there was a protest, which resulted in the severe slowing down of traffic on a motorway. Similarly, the case of Dreeman and Norway concerned direct action against whaling by Greenpeace, where a fine was considered to be proportionate in response to protest action. Now, the issue was also looked at in the case of Taraneko against Russia, and the ECHR considered that it was clear from the decided cases that contracting states' discretion in punishing illegal conduct is intertwined with expression or association, which is although wide, but was limited. And it also noted that it goes hand in hand with European supervision by the court, whose task it is to give a final ruling on whether the penalty was compatible with Article 10 or 11, noting that the court must examine with particular scrutiny cases where sanctions imposed by the national authorities for nonviolent conduct involved a prison sentence. And in the final analysis, the court in Roberts considered that the imposition of a custodial sentence did not in fact breach the individual's Article 10 rights, noting that the approach taken by the Strasbourg court accepted as proportionate both immediate sentences of imprisonment and suspended sentences in cases where the conduct in question caused less harm and was less culpable. The issue or the underlying circumstance of a peaceful protest are at the heart of the sentencing exercise, and the court noted that there were no bright lines, but particular caution was to be attached to immediate custodial sentences where the offenses arose in the exercise of the individual's right to engage in a protest. Now, the next case that I want to discuss is the case of Baladassi and France. And in fact, this case is quite recent. The judgment was handed down on Friday. And it involves the use of boycotting as a means of protest action. And the appellants in this case were convicted of inciting economic discrimination on the basis of Article 24 of the Press Freedom Act for their participation in actions calling for the boycott of products imported from Israel. And the court found that there was a violation of their Article 10 rights. And essentially, just looking briefly at the facts of this case, what the applicants did were they simply were passing around leaflets, calling on individuals to boycott products which were originated in Palestine, in Israel, sorry. And the court noted that boycotting, in resolving the issue, the court noted that boycotting doesn't necessarily amount to incitement to discriminate, because clearly calling on individuals to boycott a product as a means of protest necessarily involved inciting, on one hand, discrimination. And that was an issue that the court needed to resolve. And the court noted that in engaging in boycotting as a means of protest, there would be tensions between the exercise of freedom of expression and protest through calls for a boycott on one hand, and on the other, the call for discrimination, which is a call for intolerance together with a call for violence and hatred, which must be limited in the exercise of freedom of expression. And in resolving the issue, or in looking at whether the state's interference with the applicant's right to engage in protest through boycott, whether the interference was necessary in a democratic society, the court noted that the domestic court, that's the court in France, did not consider whether the boycott was necessary in a democratic society to achieve the legitimate purpose pursued, namely the protection of others within the meaning of Article 2. Noting as well that Article 10.2 leaves little room for restrictions of freedom of expression on matters of political discourse or matters of general importance. Noting as well that political discourse is inherently controversial and is often virulent. Nevertheless, it remains in the public interest unless it denigrates into a call for violence, hatred, and intolerance. There is the limit not to exceed. And just touching on the points, some of the points which Tom had made, there is the right to free speech. There is the right to engage in protest, and in fact, boycotts such as highlighted in this case would necessarily involve the engagement of some amount of discrimination or intolerance of a group. But the test, as is noted in this case, was whether or not that engaged in a call for violence, hatred, or intolerance, which was not the case in the case of Balagassi. The court recounted in its own jurisprudence on the application of what is necessary in a democratic society within the meaning of Article 10.2, noting in its previous case of Perinchik and the following principles that freedom of expression applies equally to favored ideas and information as well as those intended to shock, worry, and offend. Exceptions must be restrictively interpreted and the need to restrict must be convincingly established. Necessary implies a compelling social need and whether the interference is proportionate to the legitimate purpose. The case that we will look at is the case of Alkina against Russia. And in this case, the applicants complained that the institution of criminal proceedings against them, entailing their detention and conviction for a performance which they carried out back in 2012, had amounted to gross, unjustifiable, and disproportionate interference with their freedom of expression and was in breach of Article 10 of the Convention. And you may recall this case, I certainly did from my observations and its reporting in the media. The applicants were members of the performance feminist punk band Pussy Riots, and they were arrested when they attempted to perform one of their songs protesting various aspects of the state's political scene in Moscow. And they were charged with hooliganism motivated by hatred, and they were detained for up to 5 months. Now, the court considered the application of political expression as is covered by Article 10. And looking at the existence of expression, the court noted that the performance of their song, which was done from the cathedral in Moscow, in response to the ongoing political process in Russia, amounted to artistic and political expression covered by Article 10, and that the criminal sanctions which were imposed amounted to an interference with their Article 10 right. In looking at the restriction imposed, the court noted that there is no freedom of forum. So in engaging in the protest, the performers went into the public space, which was the cathedral. And in looking at this action, the court noted that there is no requirement for the automatic creation of rights of entry to private property, or even necessarily to all publicly owned property, such as, for instance, government offices and ministries. Holding an artistic performance or giving a political speech in a type of property to which the public enjoys, which in this case was the cathedral, may, depending on the nature and the function of the place, require respect for certain prescribed rules of conduct. Hence, there is the need to resolve the tension between freedom of expression, so enabling individuals such as the performance band to engage in a protest of this nature in a public space, such as the cathedral. In looking at whether or not it was proportionate to impose criminal sanctions, the court noted that the possible violation of accepted rules of conduct in a religious place of worship, such as in this case, Moscow's Christ of the Savior Cathedral, which may in principle justify the imposition of certain criminal sanctions versus the demands of the right of protesting of others. The issue for determination, however, or the litmus test, as it were, was whether the restriction of freedom of expression by imposing criminal sanctions was only acceptable in cases of incitement to hatred. The court found that the interference was not just unnecessary in a democratic society, as the applicant's actions neither contained elements of violence nor stirred up or justified violence, hatred, or intolerance of believers. So again, looking at the tension, as it were, where is the line drawn? To what extent is the individual allowed to engage in freedom of expression? And clearly the court noted that where the actions do not incite elements of hatred or there's no violence, then the interference would not be justified. And in principle, peaceful and non-violent forms of expression should not be made subject to the threat of imposition of a custodial sentence. Interference with freedom of expression in the form of criminal sanctions may have a chilling effect on the exercise of that freedom, which is an element to be taken into account when assessing the proportionality of the interference in question. The case, in addition to arresting the performers at the cathedral, the Russian courts also sought to ban the publication of videos of the band's performance on the basis that it was declared extremist. The court noted that the banning of the video recordings amounted to an interference of freedom of expression, And the issue for determination was whether the proportionality of the interference was prescribed by law. The court found that the interference was not necessary in a democratic society, in that the domestic court had failed to provide sufficient reason for the interference. And in this case, the applicants had not been allowed to challenge the findings of the local court in relation to their analysis of the video recordings. And the court found that that was a violation. And they concluded that declaring the applicants' video material on the internet extremists, placing a ban on them, did not meet a pressing social need and was disproportionate to the legitimate aim invoked. The court also noted that there is little scope under Article 10.2 for restrictions on political speech or debate where there are questions of public interest which arise. And where the views expressed do not comprise incitement to violence, the state must not restrict the right of the general public to be informed of them, even on the basis of the aims set out in Article 2, which Tom had enunciated. The next case that we will look at is another recent case, PWR against the DPP, and I believe it is on appeal to the Supreme Court. Now, the appellants were each convicted of an offense contrary to Section 13(1) of the Terrorism Act of 2000 for taking part in a demonstration in which they carried the PKK flag. And they argued that Section 13(1) of the 2000 Act does not create an offense of strict liability, and the appellants therefore could not be convicted without proof of mens rea. Alternatively, they argued that the section, if the section does create an offense of strict liability, it was incompatible with Article 10 of the European Convention of Human Rights. The Court of Appeal accepted that Article 10 was engaged because Section 13 restricted the freedom of persons to express their opinions. And the question was whether or not the restriction justified within the context of Article 10.2. In looking at the issue of proportionality, the appellants argued, in line with the ECHR jurisprudence, that Section 13 disproportionately interfered with the exercise of freedoms of expression because it was not limited to circumstances in which the expression incites violence. And as we have just discussed or looked at in the preceding cases, whether or not the particular conduct or protest incites violence is a determining factor. And so here, the appellants argued that their conduct was not such that incited violence. The Court of Appeal, however, did not consider Section 13 offense a disproportionate interference with their Article 10 rights and found that Section 13 struck a fair balance between freedom of expression and the need to protect the society against terrorism. So watch the space in relation to the developments of this particular case. And finally, I want to just touch on a bit between the overlap between Article 10 and Article 11. Article 11 deals with freedom of assembly and necessarily arises quite often in protest cases. And essentially what the jurisprudence says is that much of what is said in relation to Article 10 applies equally to the interpretation of Article 11 rights. This was considered in the case of Kasparov against Russia, where the applicants complained that their arrests following a demonstration and conviction for administrative charges had violated the freedom of expression and freedom of peaceful assembly. The court found a violation of Article 11, which was interpreted in the light of Article 10. And just briefly, the facts of the case involved a group, the engagement in a protest by a group of opposition politicians that had organized protest rallies in several Russian cities, including Moscow. They had attended a gathering which had been approved by the authorities, and they were arrested whilst they were on their way to another gathering. And it was somewhat of a setup because there were riot police deployed which prevented their onward movement to the other protest. The court considered that the dispersal and the arrest of the applicants constituted an interference with their right of peaceful assembly, as did the ensuing administrative charges brought against them because they were charged with criminal offenses. And in considering whether the interference of their right to peaceful assembly was justified, the court reiterated that an unlawful situation such as the staging of a demonstration without prior authorization. And remember, even in this case, the first protest or the first assembly had been authorized. But the court noted that even with a demonstration that has not had prior authorization, this does not necessarily justify state interference with a person's right to freedom of assembly. Noting in particular, where demonstrators do not engage in acts of violence, the public authorities must show a certain degree of tolerance towards peaceful gatherings if the freedom of assembly guaranteed by Article 11 of the Convention is not to be deprived of all substance. The state is required to show a measure of tolerance, and the questions of whether demonstration is objectionable and what action, if any, should be taken by the police should depend primarily on the nuisance being caused. That is my roundup of the cases that I wanted to discuss. Apologies for my technical glitch. Tom has had experience of my sticky fingers and not navigating my way sufficiently around the technology. But there we have it. Those were the cases that I just wanted to highlight for discussion to demonstrate, some of the tensions that arise in the exercise of one's right to peaceful protest, engage in assembly, and the observation or the litmus test, as it were, as to whether one's conduct or actions can be curtailed or ought to be curtailed by the state in the absence of violence or hate speech, as it were.
Okay, thank you very much, Thalia. We do have one question that has been put on the group chat, and it's from Patricia Tuitt. And what Patricia asks, and perhaps you both could comment on this, is obviously the cases that you've been focusing on, in particular the James case, Tom, was in the context of normal times. It didn't have the public health emergency. So how will that impact on the question of application of reasonable excuse and proportionality? And is it really going to be realistic to think that if the consequences of protest gives rise to risks to public health, that it's going to prevail in that balance?
It's a really good question. And I was trying to remember. I think the only power in the convention for states to derogate is in relation to Article 2 in times of war. There isn't any sort of a broader power to derogate, and there is the power in the Human Rights Act for ministers to say that particular legislation doesn't comply with the European Convention. But that isn't really what we're talking about here. We're talking about the margin of appreciation when deciding what's necessary and proportionate, how tight a scrutiny, how small of a gap is it that these states have got to work in terms of what's a reasonable decision and reasonable approach. And I don't think in principle it's any different in a time of public health emergency as opposed to any other time, because the criteria, the tools are there for making an assessment in any event. Because Article 10.2 and 11.2 allow the state to interfere in cases of public health and public safety, then there is the justification there. And obviously when you're assessing whether or not a interference is justified, you will have a look at the degree of the threat to public health. So, for example, if this pandemic wasn't as deadly, then that would be something which would weigh less heavily in the balance. So the degree of risk to public health is something to be put into one side of the scale. So I don't think there's any need to give a greater margin of appreciation to states in deciding how they deal with it. There is, however, a margin of appreciation that the European Court gives to the member states. But I think it's more focused on perhaps what's within the range of practical decisions. As Steph was saying, is it practical to argue that Article 10 should prevail in a time of public health emergency? And I think the answer is that it depends on the circumstances of the particular protest. And so one of the factors which needs to be borne in mind, or a number of the factors which I've mentioned in the talk, were the degree to which social distancing was being observed, because those things impact on the degree of risk. They impact on those Article 10.2 criteria, and they are factors to be put into the balance on the other side of the coin. I mean, one has to ask, when you look at the supposed concerns that the states have over the threat to public health, that the legislation, the regulations don't say that it's you can gather in groups of 6 or more if it's reasonably necessary for work and the relevant health and safety assessments have taken place and you're all 2 meters apart. And none of those criteria are in there. As far as the regulations are concerned, it's all right for you to gather in groups of 6 or more, whatever the conditions. There'll be separate legislation dealing with the health and safety aspect. But I think it would be a little rich, given some of the other exceptions to the general rule, for the state to take an overly strict view as to the practicality of it.
Alia, is there anything you want to add to that?
I think Tom has pretty much covered the, I mean, the tensions obviously would be in relation to the need to preserve public safety, public health, and it would be a question of proportionality in that context.
Okay, well, I don't think we've got any other questions. I
think one's just popped up.
Oh, has there? Sorry, if I missed that one.
Just a second come up.
Right, let me just see if I can locate that. Oh yeah. Yeah, so the question that is asked there, you'll see at the bottom, is what are the panel's views about the increasing use of PSPOs against protesters? For example, pro-life protesters outside abortion clinics.
I mean, it's one of those things which is again dependent on the facts. So there's a number of cases which have dealt with protests outside abortion clinics. They factor in issues such as the sort of material that's being displayed, whether or not there's intimidation as opposed to an attempt at persuasion, the proximity of the protests to the clinic, and so on and so forth. And obviously those are factors which will have a bearing on whether or not any public space protection order is granted based on previous conduct of protests at that location. So it depends. That's a good example as to a difficult question as to where the boundary of free speech lays. Many of us are more very pro freedom of speech wherever possible, but here there is the significant impact on the rights of others that we may not necessarily agree with, and it's a difficult question for lawyers, for any of us as individuals to grapple with. I'm going to take the easy way out and say it depends on the facts of the particular case.
I don't have a dissimilar view, Tom. I think that it would need to be fact specific, and the conduct of the protesters, and what the actions or the protest entails. Just applying some of the principles that we've just looked at. If it's peaceful, on without incitement to hate or that sort of thing, could one argue that any sort of infringement of that right would be proportionate?
And Andre's just pointed out in the comments as well, one of the other factors which I hadn't mentioned was obviously they look at whether there's going to be a counter protest and the content of the counter protest. And there's again some interesting case law which we don't have time to get into now about to what extent that any protest is going to have an impact on a counter protest and the likelihood of violence being caused by an opposing group, and how the courts and the state have to try and balance that tension with these competing rights, which is again a really interesting point which the courts have to grapple with.
We have got just to add to that, I think it's perhaps belies the proposition that was set out by Tom in the speech in his talk from the Ziegler case about the subject matter of the protest on the face said to be irrelevant. And I think that you can't really approach it in that way, because if you're focusing on protest outside of an abortion clinic, you're focusing on individuals who've made individual, obviously difficult decisions, and they are then the focus of the protest. And that has to be if the subject matter is the choices of individuals as opposed to some state action, then I think there is a difference in the balance. And it might also be in a very different context, but the PWR case is a case of major concern, because I don't know if you looked at Section 13 of the Terrorism Act, but what it prevents is anybody wearing any kind of insignia or flag or colors or any kind of symbol relating to a prescribed organization. So that's an organization that's been put on a list of terrorist organizations. But if you look at that list, it's very extensive, and it covers a wide range of groups from Al-Qaeda to the PKK and other groups that people would have to recognize that even if they're involved in violent resistance to state action, as is the case in Turkey, they also have legitimate aspects of self-defense or self-determination. And so you have got this wide-ranging group who are all treated as the same because they're on the prescribed organizations list. And so saying to diaspora communities in the United Kingdom, like Kurds or like Tamils who have armed resistance, that they can't express that through attending a march and wearing a badge or carrying a flag, is a very, very substantial intrusion on fundamental rights. And so I think that this idea, supposedly the court as the neutral arbiter, we're not going to get involved in the subject matter. One, it's wrong in principle, because it then does lead to situations like this, and actually it doesn't really work in practice. And you can see that the decisions that are taken, particularly if they're going to be at first instance decisions, that they do look at the nature of the activity. And so you can have bizarre situations where it's perfectly acceptable, it's within the law to protest outside of an abortion clinic, despite the massive distress that it causes to those women going in there. But at the same time, you're not allowed, for example, to protest outside of a shop that has fur in it, because it would cause distress to customers. Or, you know, the kind of double standards and the lack of clarity and consistency in the law is of concern. And in fact, in reality, from my looking at the case law, does turn on the court's value of what's at stake and what the implications are. So I think that is an area of difficulty.
I agree. I mean, I think it's, just to kind of summarize, it's very difficult to separate out the subject matter of a protest from the general right to protest, in the same way it's difficult to separate out sometimes the nature of the protest and the form of it. I mean, these are all incredibly closely linked. So I think as Steph says, I don't think it's possible for courts to be entirely neutral. I don't think it's right necessarily for courts to be entirely neutral on these issues. And I don't think that they are necessarily entirely neutral on these issues.
We have got some additional questions now. There's a question from Andre asking about intimidation as a separate offence under the POA, and giving his experience of cases that he's been involved in where mere presence and that protesters don't even have to speak to a person attending the clinic. Silent prayer was enough to breach the PSPO. So obviously that's following on from the earlier question.
It's an interesting point, and I think there's potentially offences like probably watching and besetting might be something that could be used. So there's potentially criminal offences that can be committed, as Andre says, even in the absence of speech, and the question of what intimidates and what amounts to intimidation is very fact specific as well. As Steph's mentioned, the distress that someone is often already under in those circumstances, I think, has to come into play.
Okay, well, I think if unless there's any questions, we are going to have a series of seminars that are going to look at some of the topics in different contexts that we've looked at today. They are going to generally be held over a lunchtime session, so I hope that will make them accessible to you and others to participate. I think probably from taking away from this talk today, and which will be followed through, is the importance of the case of Ziegler and what it's done in clarifying the law on the lawful excuse and proportionality, in particular when it comes to obstruction of the highway, which will have a big impact also on civil cases and injunctions relying on public nuisance, and that's two separate topics. But I think that that's an important case that has wide implications. Just as the boycott case that Thalia mentioned has too, there has been a concerted effort, both in terms of prosecutions and civil injunctions, to prevent protesters seeking to persuade those who support, for example, fracking through provision of support services, equipment, etc., trying to persuade them not to get involved in supporting fracking at Quadrilla. That has been, so in effect, a boycott of that particular activity. they have been the subject of a lot of concerted state action through prosecution and injunctions. And I think so that topic will be followed through, and that case is going to be important for that debate, recent as it is. Finally, I suppose the key thing is that we've had the touchstone question is for any protests that go forward in coming weeks in response to the Black Lives Matters protests, and any protest that incites hatred or violence is where the line is drawn, and we can draw our own conclusions about which sides of those protests is within the law and which are not. So thank you for everybody participating and for your contributions, and I hope that you'll attend the coming series of talks that we're putting on. The details are in the chat, and they'll also be on the website.
We just quickly, sorry, just finally just plug a few of those. I think next week we've got a session on Know Your Rights, particularly dealing with kettles and facial recognition, which has a number of members of both the civil liberties team and the crime team. And just as a flavour of what else is coming up, the following week we'll be looking at justification defences, direct action and freedom of expression. Then trial issues in protest cases, including withdrawing defences from the jury and massive expert evidence. And then on the 14th of July, we've got protest injunctions and contempt of court. So I think we've going to be covering quite a lot of really interesting stuff over the next few weeks.
Well, thanks to everyone for joining, and to my co-presenter and our chair, thank you too.
Yeah, thank you very much.